think the only way to tell your client's side of the story of a legal dispute that he or she is involved in to a newspaper or other local online media outlet is through an article written by a reporter or through an advertisement? Think again. In this video, I'll tell you about the overlooked opportunity attorneys and clients are missing out on to tell their client's side of the story to a local audience. Hi everyone, my name is Pollock. I am an attorney who helps other attorneys and their clients ethically, strategically, and proactively engage the court of public opinion. In this video, op-eds. If you've ever read a newspaper, you are familiar with an op-ed. An op-ed is an opinion piece written by someone not affiliated with the media outlet that runs opposite the editorial page in that media outlet, thus the term op-ed. Op-eds are an opportunity for an author to provide some timely insights or opinion regarding a noteworthy topic of interest to the area served by that media outlet. Thus, op-eds are opportunities for attorneys and their clients to tell their side of the story in a way that is unique. Unlike a typical news article being written by a reporter, an op-ed is not going to have the opportunity to be challenged in real time as it's being formed. A reporter is not going to ask the attorney or the client any hardball questions during an interview. There is no interview. The op-ed is an opportunity for an attorney or client to provide unfiltered and directly to the readers their opinion on an issue. These op-eds can be useful for attorneys and clients who want to tell their side of the story of a high-profile legal dispute in a way that will hopefully gain the support of the community and get other people thinking that the attorney and the client are on the right side here of the question about the legal issue. You can go online and you can find within about 2 minutes as much information as you could possibly use to help you formulate an op-ed. But I want to give you just a few tips that I think are most pertinent to attorneys and their clients using op-eds for their own purposes. So one, you've got to be concise. Generally, op-eds are between 350 and 750 words. That's not a lot of space to make your argument. So you've got to be sure that you are using words that matter and words that have impact. You've got to be persuasive. You've got to make an argument here. This is not simply you rehashing facts. This is you persuading people that are reading this article, reading your opinion piece, to come to your side and see the world from your side and your client's side. Because it has to be persuasive, you should always be thinking, why should the reader care? What am I going to say? How do I rope them in and make sure that they understand just how important this legal issue is, not to just my client and myself, but to greater society? Certainly from a plaintiff's perspective, you could talk about how if this type of conduct goes unpunished, what it would do to society. And if you're defense counsel, you could talk about how the overzealous prosecution of this kind of conduct could lead to the loss of our civil rights, civil liberties, or whatever else, whatever other arguments you might have to make. You've got to remember that these op-eds are being read by members of the general public. They don't have a deep understanding of the law. They don't have a deep understanding of legal terms. You've got to make sure you are translating for them into plain English what your argument might be. And you've got to make sure that you are not using any legalese that can confuse them and scare them away from reading the rest of your op-ed. And of course, the ethical rules still apply, and defamation law applies to these op-eds. You've got to make sure you're complying with ethical rules, notably Rule 3.6, trial publicity, as well as making sure that you are not defaming anyone when you are writing these op-eds. One last point about the mechanics of writing op-eds. I would hazard a guess that at least half of the op-eds that you read are going to be ghostwritten by someone else. So they're written by a PR person, a marketer, a freelance writer, whomever. It's not uncommon for attorneys to farm out the writing of an op-ed to another writer and then the attorney would review it before he or she submits it to the publication. Also remember that op-eds do not automatically run simply as a result of being submitted. There is a selection process, so keep that in mind, that when you're writing these op-eds and editing these op-eds, you've got to appeal not just to the public, to persuade them to see the world from your vantage point and your client's vantage point, but also you have to make sure that you're appealing to the gatekeeper and editor who is making a decision whether or not to include the op-ed in an upcoming edition of the media outlets. Attorneys and their clients often overlook op-eds as tools with which they can use to engage the court of public opinion when they're involved in high-profile legal disputes. When attorneys and their clients are developing their court of public opinion strategy, they should be considering whether there's a place for an op-ed or two. Of course, you might only get one bite at the apple when it comes to an op-ed. One legal dispute might only give rise to one op-ed. But that op-ed is a powerful tool with which attorneys can engage the court of public opinion and helpfully resolve their client's case as favorably as possible to the client.